So today's upload is Remedial Law Bar Q&A, arranged in sequenced bar questions and answers from 1997 to 2019. The arrangement and sequencing is based on the most frequently asked topics. Picking up from part 1, let us continue. Letter B, the METC denied the motion in question. A. B Lines thus filed an answer raising the defense that under the bill of lading it issued to A, its liability was limited to $10,000. At the pre-trial conference, B Lines defined as one of the issues whether the stipulation limiting its liability to $10,000 binds A. A countered that this was no longer an issue as B Lines had failed to deny under oath the bill of lading. Which of the parties is correct? The contention of B is correct. A's contention is wrong. It was A who pleaded the bill of lading as an actionable document where the stipulation limits B's liability to A to 10,000 pesos only. The issue raised by B does not go against or impugn the genuineness and due execution of the bill of lading as an actionable document pleaded by A, but invokes the binding effect of said stipulation. The oath is not required by B, because the issue raised by the latter does not impugn the genuineness and due execution of the bill of lading. 2004, plaintiff filed a complaint for a sum of money against defendant with the METC Makati. The total amount of the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, being $1 million. In due time, defendant filed a motion to dismiss the complaint on the ground of the METC's lack of jurisdiction over the subject matter. After due hearing, the METC 1. Ruled that the court indeed lacked jurisdiction over the subject matter of the complaint, and 2. Ordered that the case therefore should be forwarded to the proper RTC immediately. Was the court's ruling concerning jurisdiction correct? Was the court's order to forward the case proper? Yes. The METC did not have jurisdiction over the case because the total amount of the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs was $1 million. Its jurisdictional amount at this time should not exceed $400,000, Section 33 of BP 129 as amended. The court's order to forward the case to the RTC is not proper. It should merely dismiss the complaint. Under Section 3 of Rule 16, the court may dismiss the action or claim, deny the motion, or order the amendment of the pleading, but not to forward the case to another court. 2003, A filed with the MTC of Manila an action for specific performance against B, a resident of Quezon City, to compel the latter to execute a deed of conveyance covering a parcel of land situated in Quezon City having an assessed value of $19,000. B received the summons and a copy of the complaint on January 2, 2003. On the 10th of January 2003, B filed a motion to dismiss the complaint on the ground of lack of jurisdiction, contending that the subject matter of the suit was incapable of pecuniary estimation. The court denied the motion. In due time, B filed with the RTC a petition for certiorari praying that the said order be set aside because the MTC had no jurisdiction over the case. On February 13, 2003, A filed with the MTC a motion to declare B in default. The motion was opposed by B on the ground that his petition for certiorari was still pending. Was the denial of the motion to dismiss the complaint correct? The denial of the motion to dismiss the complaint was not correct. Although the assessed value of the parcel of land involved was $19,000 within the jurisdiction of the MTC of Manila, the action filed by A for specific performance against B to compel the latter to execute a deed of conveyance of said parcel of land was not capable of pecuniary estimation, and therefore the action was within the jurisdiction of RTC. Rosal versus Vestiel, 304 Squat 738. 2001, an amicable settlement was signed before Alupon, Tagapagmayapa, on January 3, 2001. On July 6, 2001, the prevailing party asked the Lupon to execute the amicable settlement because of the non-compliance by the other party of the terms of the agreement. The Lupon concerned refused to execute the settlement or agreement. Is the Lupon correct in refusing to execute the settlement or agreement? What should be the course of action of the prevailing party in such a case? Yes, the Lupon is correct in refusing to execute the settlement or agreement because the execution sought is already beyond the period of 6 months from the date of the settlement within which the Lupon is authorized to execute. Section 417 Local Government Code. After the 6-month period, the prevailing party should move to execute the settlement or agreement in the appropriate city or municipal trial court. Same year, Josefa filed in the Municipal Circuit Trial Court of Alicia and Mabini a petition for the probate of the will of her husband, Martin, who died in the municipality of Alicia, the residence of the spouses. The probable value of the estate, which consisted mainly of a house and lot, was placed at $95,000, and in the petition for the allowance of the will, attorney's fees in the amount of $10,000, litigation expenses in the amount of $5,000, and costs were included. Pedro, the next of kin of Martin, filed an opposition to the probate of the will on the ground that the total amount included in the relief of the petition is more than $100,000, the maximum jurisdictional amount for municipal circuit trial courts. The court overruled the opposition and proceeded to hear the case. Was the municipal circuit trial court correct in its ruling? Yes, the municipal circuit trial court was correct in proceeding to hear the case. It has exclusive jurisdiction in all matters of probate, both testate and intestate, where the value of the estate does not exceed $100,000, now $200,000. The value in this case of $95,000 is within its jurisdiction. In determining the jurisdictional amount, excluded are attorney's fees, litigation expenses, and costs. These are considered only for determining the filing fees. Section 33 of BP 129, 2000. A brings an action in the MTC of Manila against B for the annulment of an extrajudicial foreclosure sale of real property with an assessed value of 50,000 pesos located in Laguna. The complaint alleged prematurity of the sale for the reason that the mortgage was not yet due. B timely moved to dismiss the case on the ground that the action should have been brought in the RTC of Laguna. Decide with reason. The motion should be granted. The MTC of Manila has no jurisdiction because the action for the annulment of the extrajudicial foreclosure is not capable of pecuniary estimation and is therefore under the jurisdiction of the RTCs. Rosell versus Vestil. However, the action for annulment is a personal action and the venue depends on the residence of either A or B. Hence, it should be brought in the RTC of the place where either of the parties resides. 2000. A files an action in the municipal trial court against B, the natural son of A's father, for the partition of a parcel of land located in Taytay, Rizal, with an assessed value of 20,000. B moves to dismiss the action on the ground that the case should have been brought in the RTC because the action is one that is not capable of pecuniary estimation, as it involves primarily a determination of hereditary rights and not merely the bare right to real property. Resolve the motion. The motion should be granted. The action for partition depends on a determination of the hereditary rights of A and B, which is not capable of pecuniary estimation. Hence, even though the assessed value of the land is 20,000, the municipal trial court has no jurisdiction. Barangay's Lupon, Tagapamayapa, 2018. Daniel, a Filipino citizen and a permanent resident of Milan, Italy, filed with the Regional Trial Court, RTC of Davao, where she owns a rest house. A complaint for ejectment against Dan, a resident of Barangay Daliao, Davao City. Daniel's property, which is located in Diga City, Davao del Sur, has an assessed value of 25,000. Appended to the complaint was Daniel's certification of non-form shopping executed in Davao City, duly notarized by Attorney Dane Danosa, a notary public. A. Was there a need to refer the case to the Lupong Tagapamayapa for prior barangay conciliation before the court can take cognizance of the case? No, since Daniel is not an actual resident of Barangay Daliao or a barangay adjacent thereto, this case is not subject to the Katarungang Pambarangay law. Hence, prior referral to the Lupong Tagapamayapa is not a precondition to the filing of this case in court. Pascual versus Pascual. B. Was the action properly instituted before the RTC of Davao? No, Batas Pambansa 129 vests the municipal trial court with the exclusive jurisdiction on unlawful detainer cases, regardless of the assessed value of the property. Hence, the action was wrongfully instituted with the RTC. Should the complaint be verified, or is the certification sufficient? Yes. Considering that the action for unlawful detainer, the rules and summary procedure will apply. Rule 2, Section 3, letter B of the Rules on Summary Procedure requires that all pleadings submitted to the court be verified. Hence, a mere certification of non-form shopping, the complaint being initiatory pleading, is insufficient. 2009. Mariano, through his attorney-in-fact, Marcos, filed with the RTC of Baguio City a complaint for annulment of sale against Henry. Marcos and Henry both reside in Asin Road, Baguio City, while Mariano resides in Davao City. Henry filed a motion to dismiss the complaint on the ground of prematurity for failure to comply with the mandatory barangay conciliation. Resolved the motion with reason. The motion to dismiss should be denied because the parties in interest, Mariano and Henry, do not reside in the same city or municipality, or is the property subject of the controversy situated therein. The required conciliation or mediation before the proper barangay as mandated by the local government code governs only when the parties to the dispute resides in the same city or municipality, and if involving real property, as in this case, the property must be situated also in the same city or municipality. 2001. An amicable settlement was signed before a Lupon Tagapamayapa on January 3, 2001. On July 6, 2001, the prevailing party asked the Lupon to execute the amicable settlement because of the non-compliance by the other party of the terms of the agreement. The Lupon concerned refused to execute the settlement or agreement. Is the Lupon correct in refusing to execute the settlement or agreement? What should be the course of action of the prevailing party in such a case? Yes, the Lupon is correct in refusing to execute the settlement or agreement because the execution sought is already beyond the period of 6 months from the date of the settlement within which the Lupon is authorized to execute. After the 6-month period, the prevailing party should move to execute the settlement or agreement in the appropriate city or municipal trial court. Government agencies, 2006. In 1996, Congress passed Republic Act 8189, otherwise known as the Voters Registration Act of 1996, providing for computerization of elections. Pursuant thereto, the COMELEC approved the Voters Registration and Identification System, or VRIS, project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Futokina was declared the winning bidder with a bid of 6 billion and was issued a notice of award. But COMELEC Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the COMELEC's modernization is only 1 billion. He announced to the public that the VRIS project has been set aside. 2 commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Fotokina filed with the RTC a petition for mandamus to compel the COMELEC to implement the contract. The Office of the Solicitor General OSG representing German Go opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the COMELEC and bank to oppose the petition. May the OSG represent Chairman Go before the RTC, notwithstanding that his position is contrary to that of the majority? Yes. The OSG may represent the COMELEC chairman before the RTC, notwithstanding that his position is contrary to that of a majority of the Commission's member in the COMELEC, because the OSG is an independent office. Its hands are not shackled to the cost of its client agency. The primordial concern of the OSG is to see to it that the best interests of the government is upheld. COMELEC versus Cuyano Padilla, September 18, 2002. 2006. What court has jurisdiction over an action for specific performance filed by a subdivision homeowner against a subdivision developer? Choose the correct answer. Explain. Letter A, the Housing and Land Use Regulatory Board. B, the Securities and Exchange Commission. C, the Regional Trial Court. D, the Commercial Court or the Regional Trial Court designated by the Supreme Court to hear and decide commercial cases. An action for specific performance by a subdivision homeowner against a subdivision developer is within the jurisdiction of the Housing and Land Use Regulatory Board. Section 1 of PD 1344 provides that the HLURB has jurisdiction over cases involving specific performance of contractual and statutory obligations filed by buyers of subdivision lots and condominium units against the owner, developer, dealer, broker, or salesman. Manila Bankers Life Insurance Corporation versus Eddie Ng Kok Wee. Docket fees, 2018. Denise Incorporated and David, both stockholders owning collectively 25% of Darwinkle Incorporation, filed an action before the RTC of Makati to compel its board of directors to hold the annual stockholders meeting on June 21, 2017, as required by Darwinkle Incorporated's bylaws, with prayer for preliminary mandatory injunction to use as record date April 30, 2017. The complaint alleged, among others, that the refusal to call the annual stockholders meeting, or SAM, on June 24, 2017 was rooted in the plan of the BOD to allow Databanks Incorporation, which would have owned 50% of Darwinkle's Corporation after July 15, 2017, to participate in the ASM to effectively dilute the complainant's shareholdings and ease them out of the BOD. Then Denise Incorporation and David paid them out of $7,565 as filing fees based on the assessment of the clerk of court. The BOD filed a motion to dismiss on the ground of lack of jurisdiction. They averred that the filing fees should have been based on the actual value of the shares of Denise Inc. and David, which were collectively worth $450 million. If you were the judge, will you grant the motion to dismiss? No. While the payment of the prescribed docket fee is a jurisdictional requirement, even if its non-payment at the time of filing does not automatically cause the dismissal of the case, the court may allow payment of the fee within a reasonable time, but in no case beyond the applicable prescriptive or reglementary period. Here, Denise Incorporation and David merely relied on the assessment made by the clerk of court. If incorrect, the clerk of court has the responsibility of reassessing how much they must pay within the prescription period. Proton Filipinas versus Banque Nationale de Paris. GR 1512-42, June 15, 2005. Alternative answer: no, since the case is an intra-corporate suit. BOD's motion to dismiss on the ground of deficient filing fees must be denied for being a prohibited pleading. Under Rule 1, Section 8 of the Interim Rules on Intracorporate Controversies, a motion to dismiss is a prohibited pleading. Civil Procedure, Civil Actions, Rule 2 to 5, Cause of Action, 2017. Elise obtained a loan of $3 million from a merchant bank. Aside from executing a promissory note in favor of merchant bank, she executed a deed of real estate mortgage over her house and lot as security for her obligation. The loan fell due but remained unpaid. Hence, merchant bank filed an action against Elise to foreclose the real estate mortgage. A month later, or a month after, and while the foreclosure suit was pending, merchant bank also filed an action to recover the principal sum of $3 million against Elise based on the same promissory note previously executed by the latter. In opposing the motion of Elise to dismiss the second action of the ground of splitting of a single cause of action, merchant bank argued that the ground relied upon by Elise was devoid of any legal basis, considering that the two actions were based on separate contracts, namely the contract of loan evidenced by the promissory note and the deed of real estate mortgage. Is there a splitting of a single cause of action? Explain your answer. Yes, there is a splitting of a cause of action. A creditor cannot file a civil action against the debtor for collection of the debt and subsequently file an action to foreclose the mortgage. This is an example of splitting a single cause of action, a practice that is vexatious and oppressive. Dunau v. Court of Appeals, 2015. Lender extended to borrower a $100,000 loan covered by a promissory note. Later, borrower obtained another 100,000 peso loan, again covered by a promissory note. Still later, borrower obtained a 300,000 loan secured by a real estate mortgage on his land valued at 500,000 pesos. Borrower defaulted on his payment when the loan matured. Despite demand to pay the 500,000 loan, borrower refused to pay. Lender, applying the totality rule, filed against borrower with the Regional Trial Court of Manila a collection suit for 500,000 pesos. A. Did the lender correctly apply the totality rule and the rule on joinder of causes of action? The answer is yes. The lender correctly applied the totality rule and the rule on joinder of causes of action because where the claims in all the causes of action are principally for recovery of money, the aggregate amount of the claim shall be the test of jurisdiction. Section 5, letter D, Rule 2, Rules of Court. Here, the total amount of the claim is 500,000. Hence, the Regional Trial Court of Manila has jurisdiction over the suit. At any rate, it is material that one of the loans secured by a real estate mortgage because the lender opted to file a collection of sum of money instead of foreclosure of the said mortgage. At the trial, borrower's lawyer, while cross-examining lender, successfully elicited an admission from the latter that the two promissory notes have been paid. Thereafter, borrower's lawyer filed a motion to dismiss the case on the ground that is proven only 300,000 was the amount due to lender and which claim is within the exclusive original jurisdiction of the Metropolitan Trial Court. He further argued that lack of jurisdiction over the subject matter can be raised at any stage of the proceedings. Should the court dismiss the case? The answer is no. The court should not dismiss the case. What determines the jurisdiction of the court is the nature of the action pleaded as appearing from the allegations in the complaint. The averments therein and the character of the relief sought are the ones to be consulted. Navida v. Honorable Teodoro Dizon. TR 125078, May 30, 2011. Accordingly, even if the defendant is able to prove in the course of the trial that a lesser amount is due, the court does not lose jurisdiction and a dismissal of the case is not in order. Paadlan versus Tinglasan. 2012. A bought a Volvo sedan from ABC Cars for $5 million. ABC Cars, before delivering to A, had the car rust-proofed and tinted by XYZ Detailing. When delivered to A, the car's upholstery was found to be damaged. ABC Cars and XYZ Detailing both deny any liability. Who can A sue and on what costs or causes of action? A can file an action for specific performance and damages against ABC Cars since the damage to the Volvo sedan's upholstery was caused before the delivery of the same to A, and therefore prior to the transfer of ownership to the latter. Article 1477 of the Civil Code, under Articles 1170 of the Civil Code, those who contravene the tenor of the obligation are liable for damages. Hence, an addition for specific performance against ABC Corporation to deliver the agreed Volvo sedan in the contract, free from any damage or defects, with corresponding damages will lie against ABC Cars. Alternative answer. A can sue ABC Cars for specific performance or rescission because the former has contractual relations with the latter. 2006. What do you mean by real actions and by personal actions? Real actions are actions affecting title to or possession of real property or an interest therein. Fortune Motors versus CA. All other actions are personal actions. Rule 4, Section 1, which include those arising from privity of contract. 2005. Rafael, a warehouse man, filed a complaint against B Corporation, X Corporation, and Y Corporation to compel them to interplead. He alleged therein that the three corporations claimed the title and right of possession over their goods deposited in his warehouse and that he was uncertain which of them was entitled to the goods. After due proceedings, judgment was rendered by the court declaring that X Corporation was entitled to the goods. The decision became final and executory. Rafael filed a complaint against X Corporation for the payment of $100,000 for storage charges and other advances for the goods. X Corporation filed a motion to dismiss the complaint on the ground of res judicata. X Corporation alleged that Rafael should have incorporated in his complaint for interpleader his claim for storage fees and advances, and that for his failure he was barred from interposing his claim. Rafael replied that he could not have claimed storage fees and other advances in his complaint for interpleader because he was not yet certain as to who was liable therefore. Resolved the motion for read reason. The motion to dismiss should be granted. Rafael should have incorporated in his complaint for interpleader his claim for storage fees and advances, the amounts of which were obviously determinable at the time of the filing of the complaint. They are part of Rafael's cause of action, which he may not split. Hence, when the warehouse man asked the court to ascertain who among the defendants are entitled to the goods, he also has the right to ask who should pay for the storage fees and other related expenses. The filing of the interpleader is available as a ground for dismissal of the second case. Section 4, Rule 12. It is akin to a compulsory counterclaim, which is, if not set up, shall be barred. 2005. Perry is a resident of Manila, while Ricky and Marvin are residents of Batangas City. They are co-owners of a parcel of residential land located in Pasay City with an assessed value of $100,000. Perry borrowed $100,000 from Ricky with a promissory, or which he promised to pay on or before December 1, 2004. However, Perry failed to pay his loan. Perry also rejected Ricky and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the RTC of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's 100,000 peso loan, plus interest and attorney's fees. Stated with reasons whether it was proper for Ricky to join his cause of action in his complaint for petition against Perry and Marvin in the RTC of Pasay. It was not proper for Ricky to join his cause of action against Perry in his complaint for petition against Perry and Marvin. The causes of action may be between the same parties, Ricky and Perry, with respect to the loan, but not with respect to the partition, which includes Marvin. The joinder is between a partition and a sum of money, but partition is a special civil action under Rule 69, which cannot be joined with other causes of action. Also, the causes of action pertain to different venues and jurisdictions. The case for a sum of money pertains to the municipal court and cannot be filed in Pasay City because the plaintiff is from Manila, while Ricky and Marvin are from Batangas City. 2002. Rolando filed a petition for declaration of the nullity of his marriage to Carmela because of the alleged psychological incapacity of the latter. After trial, the court rendered judgment dismissing the petition on the ground that Rolando failed to prove the psychological incapacity of his wife. The judgment having become final, Rolando filed another petition, this time on the ground that his marriage to Carmela had been celebrated without a license. Is the second action barred by the judgment in the first? Why? No, the second action is not barred by the judgment in the first because there are different causes of action. The first is for annulment of marriage on the ground of psychological incapacity under Article 36 of the Family Code, while the second is for a declaration of nullity of the marriage in view of the absence of basic requirement, which is a marriage license. Articles 9 and 35 of the Family Code. There are different causes of action because the evidence required to prove them are not the same. Pagsisihan versus Court of Appeals. It is admitted that the second action cannot be maintained because the parties are barred by estoppel. When Rolando filed the first action, he alleged in the petition that they are validly married. He cannot therefore belie the fact in the second action. I think may case na ganito wherein the Supreme Court decided that estoppel applied to the case. 1999. What is the rule against pleading of cause of action and its effect on the respective rights of the parties for failure to comply with the same? A purchased a lot from B for 1.5 million. He gave a down payment of 500,000, signed a promissory note payable within 30 days after date, and as a security for the settlement of the obligation mortgaged the same lot to B. When the note fell due and A failed to pay, B commenced suit to recover from A the balance of 1 million. After securing a favorable judgment in his claim, B brought another action against A before the same court to foreclose the mortgage. A now files a motion to dismiss the second action on the ground of bar by prior judgment. Rule on the motion. The rule against pleading of cause of action and its effect are that if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in one or in any one is available as a ground for the dismissal of the others. Section 4, Rule 2. The motion to dismiss should be granted. When B commenced suit to collect on the promissory note, he waived his right to foreclose the mortgage. B split his cause of action. What is the rule on joinder of causes of action? The rule on joinder of causes of action is that a party may in one pleading assert in the alternative or otherwise join as many causes of action as he may have against an opposing party, provided that the rule on joinder of parties is complied with. 1. The joinder shall not include special civil actions or actions governed by special rules, but may include causes of action pertaining to different venues or jurisdictions provided one cause of action falls within the jurisdiction of RTC and venue lies therein. And number 2, the aggregate amount claimed shall be the test of jurisdiction, where the claims in all the causes of action are principally for the recovery of money. Section 5, Rule 2 of the 1997 rules. A secured 2 loans from B, one for 500,000 and the other for 1 million, payable on different dates. Both have fallen due. Is B obliged to file only one complaint against A for the recovery of both loans? No. Joinder is only permissive since the loans are separate loans, which may be governed by the different terms and conditions. The 2 loans give rise to 2 separate causes of action and may be the basis of 2 separate complaints. Distinguish action from cause of action. An action is one by which a party sues another for the enforcement or protection of a right or the prevention or redress of a wrong. Section 3, letter A, Rule 2. A cause of action is the act of or omission by which a party violates a right of another. Section 2, Rule 2 of the 1997 rules. An action must be based on a cause of action. That's in Section 1, Rule 2 of the 1997 rules. Give the effect of the following: splitting a single cause of action and non-joinder of a necessary party. The effect of splitting a single cause of action is found in the rule as follows. If 2 or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment on the merits in any one is available as a ground for the dismissal of the others. The effect of the non-joinder of a necessary party may be stated as follows. The court may order the inclusion of an omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause to a waiver of the claim against such person. The court may proceed with the action, but the judgment rendered shall be without prejudice to the rights of each necessary party. Rule 3. Parties to the civil action. Hannah, a resident of Manila, filed a complaint for the partition of a large tract of land located in Oriental Mindoro. She impleaded her 2 brothers, John and Adrian, as defendants, but did not implead Lika and Agatha, her 2 sisters, who were permanent residents of Australia. Arguing that there could be no final determination of the case without impleading all indispensable parties, John and Adrian moved to dismiss the complaint. Does the trial court have reason to deny the motion? Yes, the trial court has reason to deny the motion. Section 11, Rule 3, Rules of Court states that neither misjoinder nor non-joinder of parties is a ground for the dismissal of an action. The petitioner can still amend his initiatory pleading in order to implead Leica and Agatha, for under the same rule, such amendment to implead an indispensable party may be made on motion of any party or on the trial court's own initiative at any stage of the action, and on such terms as are just. Ablasa v. Republic. GR 158298, August 11, 2010. Spouses Marlon and Edith have 3 children ages 15, 12, and 7 who are studying at the public schools. They have a combined gross monthly income of 30,000 and they stay in an apartment in Manila with a monthly rent of 5,000. The monthly minimum wage per employee in Manila does not exceed 13,000. They do not own any real property. The spouses want to collect a loan of 25,000 from Jojo but do not have the money to pay the filing fees. Would the spouses qualify as indigent litigants under Section 19, Rule 141 of the legal fees? B. If the spouses do not qualify under Rule 141, What other remedy can they avail of under the rules to exempt him from paying the filing fees? No, spouses Marlon and Edith would not qualify as indigent litigants. Under Section 19 of Rule 141, indigent litigants include those A. whose gross income and that of their immediate family do not exceed an amount double the monthly minimum wage of an employee, and B. who do not own real property with a fair market value as stated in the current tax declaration of more than 300,000 pesos shall be exempt from payment of legal fees. Section 19, Rule 141, Administrative Matter Number 04204. Here, the spouse's combined gross monthly income of 30,000 exceeds the limit provided by Section 19, Rule 141. Accordingly, the spouses do not qualify as indigent litigants. The spouses can avail of the following remedies under the rules in order to be exempted from the payment of the filing fees. 1. If the applicant for exemption meets the salary and property requirements under Section 19 of Rule 141, then the grant of the application is mandatory. On the other hand, when the application does not satisfy one or both requirements, then the application should not be denied outright. Instead, the court should apply the indigency test under Section 21 of Rule 3 and use its sound discretion in determining the merits of the prayer for exemption. Algura versus Local Government Unit of City of Naga. Hence, the spouses may be authorized to litigate as indigent if the court, upon an ex parte application and hearing, is satisfied that they do not have any money or property sufficient and available for food, shelter, and basic necessities for themselves and their family. Number 2, the spouses can also file a motion to sue as indigent under the rules of procedure on small claims. The motion shall be referred to as the executive judge for immediate action in case of multi-sala courts. If the motion is granted by the executive judge, the case shall be raffled off or assigned to the court designated to hear small claims cases. If the motion is denied, the plaintiff shall be given 5 days within which to pay the docket fees. Otherwise, the case shall be dismissed without prejudice. In no case shall a party, even if declared an indigent, be exempt from the payment of the 1,000 fee for service of summons and processes. Number 3, the spouses may also claim exemption from payment of legal fees by seeking the help of the Integrated Bar of the Philippines pursuant to AM number 08117 SC. Rule on the exemption from the payment of legal fees of the clients of the National Committee on Legal Aid and of the legal aid offices in local chapter of the Integrated Bar of the Philippines. 2009. Florencio sued Guillermo for partition of a property they own in common. Guillermo filed a motion to dismiss the complaint because Florencio failed to plead Hirando and Inocencio, the other co-owners of the property. As judge, will you grant the motion to dismiss? No, because the non-joinder of parties is not a ground for dismissal of action. The motion to dismiss should be denied. 2007. B files a petition for cancellation of the birth certificate of her daughter R on the ground that the falsified material entries therein made by B's husband as the informant. The RTC sets the case for hearing and directs the republication or publication of the order for hearing and directs the publication of the order once a week for 3 consecutive weeks in a newspaper of general circulation. Summons was serviced on the civil register, but there was no appearance during the hearing. The RTC granted the petition. R filed a petition for annulment of judgment before the Court of Appeals, saying that she was not notified of the petition and hence the decision was issued in violation of due process. B opposed, saying that the publication of the court order was sufficient compliance with due process rule. R's petition for annulment of judgment before the Court of Appeals should be granted. Although there was publication of the Court of Order acting the petition to cancel the birth certificate, reasonable notice still has to be served on R, as she has an interest affected by the cancellation. Section 3 and 4, Rule 108, Rules of Court. She is an indispensable party, Republic versus Benemerito, and notice has to be served on her not for the purposes of vesting the court with jurisdiction, but to comply with the requirements of fair play and due process. Ceruilla versus Delantar, 477 SCRA 134. Alternative answer. The petition for annulment of judgment should not be granted. While R is an indispensable party, it has been held that the failure to service notice on indispensable parties is cured by the publication made because the action is one in rem. Distinguish a derivative suit from a class suit. A derivative suit is a suit in equity that is filed by a minority shareholder in behalf of a corporation to redress wrongs committed against it for which the directors refuse to sue, the real party in interest being the corporation itself. While a class suit is filed regarding a controversy of common or general interest in behalf of many persons, so numerous that it is impracticable to join all as parties, a number which the court finds sufficiently representative who may sue or defend for the benefit of all. It is worth noting that derivative suit is a representative suit just like a class suit. 2000. PJ engaged the services of attorney SD to represent him in a civil case filed by OP against him, which was docketed as civil case number 123. A retainer agreement was executed between PJ and attorney SD, whereby PJ promised to pay attorney SD a retainer sum of $24,000 a year and to transfer the ownership of a parcel of land to attorney SD after presentation of PJ's evidence. PJ did not comply with his undertaking. Attorney SD filed a case against PJ, which was docketed as civil case number 456. During the trial of the civil case number 456, PJ died. Is the death of PJ a valid ground to dismiss the money claim of attorney SD in civil case number 456? Explain. No, under Section 20, Rule 3, 1997 Rules of Civil Procedure, when the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action is pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner especially provided in the rules for prosecuting claims against the state of a deceased person. Will your answer be the same with respect to the real property being claimed by attorney SD in civil case number 456? Explain. Yes, my answer is the same. An action to recover real property in any event survives the death of the defendant. Section 1, Rule 87, Rules of Court. However, a favorable judgment may be enforced in accordance with Section 7, letter B, Rule 39, 1997, Rules of Civil Procedure, against the executor or administrator of, or successor in interest of the deceased. What is the effect of the death of a party upon a pending action? When the claim in a pending action is purely personal, the death of either the parties extinguishes the claim and the action is dismissed. When the claim is not purely personal and is not thereby extinguished, the party should be substituted by his heirs or his executor or administrator. Section 16, Rule 3. If the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment, in the court in which the action was pending at the time of such death, it shall not be dismissed, but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner provided in the rules for prosecuting claims against the estate of a deceased person, Section 20, Rule 3, 1999, when A. Buyer failed to pay the remaining balance of the contract price after it became due and demandable. B. The seller sued him for collection before the RTC. After both parties submitted their respective evidence, A perished in a plane accident. Consequently, his heirs brought an action for the settlement of his estate and moved for the dismissal of the collection suit. Will you grant the motion? Explain. No, because the action will not be dismissed but shall instead be allowed to continue until entry of final judgment. Will your answer be the same if A died while the case is already on appeal to the Court of Appeals? Explain. No, if A died while the case was already on appeal in the Court of Appeals, the case will continue because there is no entry yet of final judgment. In the same case, what is the effect if B died before the RTC has rendered judgment? The effect is the same. The action will not be dismissed, but will be allowed to continue until entry of final judgment. 1998. A filed a complaint for the recovery of ownership of land against B, who was represented by her counsel X. In the course of the trial, B died. However, X failed to notify the court of B's death. The court proceeded to hear the case and rendered judgment against B. After the judgment became final, a writ of execution was issued against C, who, being B's sole heir, acquired the property. If you were the counsel of C, what course of action would you take? As counsel of C, I would move to set aside the writ of execution in the judgment for lack of jurisdiction and lack of due process in the same court because the judgment is void. If X had notified the court of B's death, the court would have ordered the substitution of the deceased by C, the sole heir of B, Section 16, Rule 3. The court acquired no jurisdiction over C, upon whom the trial and the judgment are not binding. Ferreira versus Ibarra, VDA de Gonzalez. I could also file an action to annul the judgment for lack of jurisdiction because C, as the successor of B, was deprived of due process and should have been heard before judgment. Rule 47. Alternative answer. While there are decisions of the Supreme Court which hold that if the lawyer failed to notify the court of his client's death, the court may proceed even without substitution of heirs, and the judgment is valid and binding on the heirs of the deceased. Florendo versus Coloma. As counsel of C, I will assail the judgment and execution for lack of due process. Venue of Actions, 2017. After working for 25 years in the Middle East, Evan returned to the Philippines to retire in Manila, the place of his birth and childhood. 10 years before his retirement, for cash in his name, a house and lot in Malate, Manila. 6 months after his return, he learned that his house and lot were the subject of foreclosure proceedings commenced by ABC Bank on the basis of a promissory note and a deed of real estate mortgage he had allegedly executed in favor of AC Bank 5 years earlier. Knowing that he was not in the country at the time the promissory note and deed of mortgage were supposedly executed, Evan forthwith initiated a complaint in the RTC of Manila, praying that the subject documents be declared null and void. ABC Bank filed a motion to dismiss Evan's complaint on the ground of improper venue on the basis of stipulation in both documents designating Quezon City as the exclusive venue in the event of litigation between the parties arising out of the loan and mortgage. Should the motion be dismissed of ABC Bank be granted? No, ABC Bank's motion to dismiss should be denied. In Briones versus Court of Appeals, the Supreme Court ruled that the complaint directly assailing the validity of the written instrument itself should not be bound by the exclusive venue stipulation contained therein and should be filed in accordance with the general rules on venue. The Supreme Court ruled that if it would be inherently inconsistent for a complaint of this nature to recognize the exclusive venue stipulation when it, in fact, precisely assails the validity of the instrument in which such stipulation is contained. In this case, Evans' complaint directly assails the validity of the promissory note and deed of mortgage, which contains said venue stipulation. Hence, said venue stipulation is not binding on him. Evans correctly filed his complaint with the Manila RTC pursuant to the rules of court. 2016. Eduardo, a resident of the city of Manila, filed before the RTC of Manila a complaint for the annulment of a deed of real estate mortgage he signed in favor of Galaxy Bank, and the consequent foreclosure and auction sale of his mortgage, Makati property. Galaxy filed a motion to dismiss on the ground of improper venue, alleging that the complaint should be filed with the RTC of Makati since the complaint involves the ownership and possession of Eduardo's lot. Resolved the motion with reasons. The motion to dismiss should be granted. An action for nullification of the mortgage documents and foreclosure of the mortgage property is a real action that affects the title to the property. Thus, venue of the real action is before the court having jurisdiction over the territory in which the property lies. Jimmy T. Go versus United Coconut Planters. In Fortune Motors versus Court of Appeals, the Supreme Court also held that an action to annul a foreclosure sale of a real estate mortgage is no different from an action to annul a private sale of real property. While it is true that petitioner does not directly seek the recovery of title or possession of the property in question, his action for annulment of sale and his claim for damages are closely intertwined with the issue of ownership of the building, which, under the law, is considered immovable property, the recovery of which is petitioner's primarily objective. The prevalent doctrine is that an action for the annulment or rescission of a sale of real property does not operate to efface the fundamental and prime objective and nature of the case, which is to recover said real property. It is a real action. Paglaum Management and Development Corporation versus Union Bank of the Philippines. Being a real action, it shall be commenced and tried in the proper court, which has jurisdiction over the area where the real property involved or a portion thereof is situated. The complaint should be filed in the RTC of Makati, where the mortgage property is situated. Alternative answer: the motion to dismiss should be denied. An action for the annulment of a real estate mortgage is a personal action which may be commenced and tried where the defendant or any of the defendants resides or may be found, or where the plaintiff or any of the plaintiffs resides or may be found, at the election of the plaintiff. Section 2, Rule 4, Rules of Court. 2 versus total of his products and services. Since the plaintiff resides in Manila, the complaint was properly filed in the RTC of Manila. 2013. While leisurely walking along the street near her house in Marikina, Patty unknowingly stepped on a garden tool left behind by CCC, a construction company based in Makati. She lost her balance as a consequence and fell into an open manhole. Fortunately, Patty suffered no major injuries except for contusions, bruises, and scratches that did not require any hospitalization. However, she lost self-esteem, suffered embarrassment and ridicule, and had bouts of anxiety and bad dreams about the accident. She wants vindication for her uncalled experience and hires you to act as counsel to do whatever is necessary to recover at least 100,000 pesos for what she suffered. What action or actions may Patty pursue, against whom, where, court and venue, and under what legal basis? Patty may avail of the following remedies. She may file a complaint for damages arising from fault or negligence under the rules on small claims against CCC Company before the MTC of Marikina City, where she resides, or Makati City, where the defendant corporation is holding office at her option. AM number 887, Supreme Court, in relation to Section 2, Rule 4, Rules of Court. B. She may also file an action to recover moral damages based on quasi-delict under Article 2176 of the new Civil Code. The law states that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called quasi-delict. Under Article 2217 of the new Civil Code, moral damages include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate result of the defendant's wrongful act or omission. Since moral damages are incapable of pecuniary estimation, Patty should file the action before the Regional Trial Court of Marikina, where she resides, or Makati City, where the defendant corporation is holding office at her option. Letter C. Patty can also file action, a civil action, for damages against the City of Marikina for maintaining an open manhole where she unfortunately fell. Under Article 2189 of the Civil Code, provinces, cities, and municipalities shall be liable for damages for the death or injuries suffered by any person by reason of the defective condition of roads, streets, bridges, public buildings, and other public works under their control or supervision. The proper court having jurisdiction over the case is at least 100,000 for as long as the aggregate of the claims for damages does not exceed 400,000. 2012. A. A resident of Quezon City wants to file an action against B, a resident of Pasay, to compel the latter to execute a deed of sale covering a lot situated in Marikina, and that transfer of title be issued to him claiming ownership of the land. Where should A file the case? A should file the case in Marikina, the place where the real property subject matter of the case is situated. An action for specific performance would still be considered a real action where it seeks the conveyance or transfer of real property, or ultimately the execution of deeds of conveyance of real property. Gotchan versus Gotchan. Letter A. Angela, a resident of Quezon City, sued Antonio, a resident of Makati City, before the RTC of Quezon City for the reconveyance of two parcels of land situated in Tarlac and Nueva Ecija, respectively. May her action prosper? No, the action will not prosper because it was filed in the wrong venue. Since the action for reconveyance is a real action, it should have been filed separately in Tarlac and Nueva Ecija, where the parcel of lands are located. Section 1, Rule 4, United Overseas Bank of the Philippines versus Rosemore Mining and Development Corporation. However, an improperly laid venue may be waived if not pleaded in a timely motion to dismiss. Without a motion to dismiss on the ground of improperly laid venue, it would be incorrect for the court to dismiss the action for improper venue. Assuming that the action was for foreclosure of the mortgage of the same parcel of land, what is the proper venue for the action? The action must be filed in any province where any of the lands involved lies, either in Tarlac or in Nueva Ecija, because the action is a real action. BPI versus Green. However, an improperly laid venue may be waived if not pleaded as a ground for dismissal. A resident of Lingayen, Pangasinan sued ex-resident of San Fernando, La Union in the RTC of Quezon City for the collection of a debt of 1 million. X did not file a motion to dismiss for improper venue but filed his answer raising therein improper venue as an affirmative defense. He also filed a counterclaim for 80,000 against A for attorney's fees and expenses for litigation. X moved for a preliminary hearing on said affirmative defense. For his part, A filed a motion to dismiss the counterclaim for lack of jurisdiction, ruled on the affirmative defense of improper venue. There is improper venue. The case for a sum of money, which was filed in Quezon City, is a personal action. It must be filed in the residence of either the plaintiff, which is in Pangasinan, or of the defendant, which is in San Fernando, La Union. Section 2 of Rule 4. The fact that it was not raised in a motion to dismiss does not matter because the rule that if improper venue is not raised in a motion to dismiss, it is deemed waived was removed from the 1997 Rule of Civil Procedure. The new rules provide that if no motion to dismiss has been filed, any of the grounds for dismissal may be pleaded as an affirmative defense in the answer. Ex-resident of Angeles City borrowed 300,000 from A resident of Pasay City. In the loan agreement, the parties stipulated that the parties agreed to sue and be sued in the City of Manila. In case of non-payment of the loan, can A file his complaint to collect the loan from X in Angeles City? Yes, because the stipulation in the loan agreement that the parties agreed to sue and be sued in the City of Manila does not make Manila the exclusive venue thereof. Section 4, Rule 4, as amended by Circular Number 1395. A can file his complaint in Angeles City where he resides. Suppose the parties did not stipulate in the loan agreement as to the venue. Where can A file his complaint against? If the parties did not stipulate of the venue, A can file his complaint either in Angeles City, where he resides, or in Pasay City, where X resides. Suppose the parties stipulated in their loan agreement that venue for all suits arising from this contract shall be the courts in Quezon City. Can A file his complaint against X in Pasay City? Yes, because the wording of the stipulation does not make Quezon City the exclusive venue. Field Banking versus Tensuan. Alternative answer, no. If the parties stipulated that the venue shall be in the courts in Quezon City, A cannot file his complaint in Pasay City because the use of the word shall makes Quezon City the exclusive venue thereof. A motion is not a pleading, but a mere application for relief other than by a pleading. A counterclaim is a pleading. True, a counterclaim is a pleading by which a defending party makes a claim against an opposing party. 31. Part 3 is coming up and we'll pick up from here. So if you're not subscribed to our channel, go ahead and hit the subscribe button and let's study together. Thank you.